Imagine two athletes stepping onto a starting block. One went through natural male puberty, and, well, the other didn't.
Right.
For over 50 years, Title IX has used, a pretty simple biological line to decide who races whom. It's an attempt to guarantee equal athletic opportunity for women. But today that biological line has been, it's essentially been erased in the eyes of many, replaced by really complex questions about identity. Welcome to the debate. We are looking at what happens when the legal definitions of fairness collide with the physiological realities of human biology.
Yeah, it's a profound legal collision, really. We have to ask whether categorically banning an athlete based on their biological sex at birth is actually preserving fairness, or, if it is simply enforcing an overbroad, unconstitutional exclusion against a vulnerable minority.
Exactly. So today we're diving into the Supreme Court's June 30, 2026 rulings in West Virginia v. B.P.J. and Little v. Haycox. The central question is whether the Equal Protection Clause and Title IX allows states to categorically ban transgender women and girls from competing on female sports teams based exclusively on their biological sex identified at birth. I support the court's majority view that relying on biological classifications is legally sound, practically necessary, and serves the critical interests of safety and fairness for female athletes.
And I support the minority view. These blanket bans are unconstitutionally overbroad, and they unfairly ignore the individual circumstances of transgender girls who have actually never undergone male puberty.
If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications so you'll always know when new content is released. As a quick update, we continue to monitor the Martin Stevens vs. OpenAI matter. It is important to note that this is still not a lawsuit. Martin Stevens has suspended his voluntary quiet period after OpenAI filed its confidential S-1 registration statement on June 8, 2026, without first engaging with him, despite having nearly a month since his final notice and more than a year since his initial notifications. Stevens views OpenAI's decision to proceed without any direct interaction as a sign of extreme disrespect. As a result, he has stated that he will not re-enter a quiet period unless it is part of a formal agreement. At the time of this recording, no settlement discussions or negotiations have been publicly confirmed. We could also report that the dead man's switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates if circumstances change. But for now, let's turn our attention back to the Supreme Court and the future of Title IX. When you read Justice Kavanaugh's majority opinion, he really anchors the whole framework on this concept of intermediate scrutiny.
Right, which is the specific legal hurdle any law based on sex has to clear.
Exactly. For those listening, intermediate scrutiny sits right between strict scrutiny, which we use for laws targeting race, and rational basis, which is, a much lower bar. To survive intermediate scrutiny, a law has to be substantially related to an important government objective.
Sure.
And the court recognized that biological differences between males and females aren't just social constructs. They are physical realities.
But we have to be very precise about what those physical realities actually are in this specific context.
Well, biology dictates them. We're talking about inherent physiological traits: larger lung capacity, higher bone density, a different skeletal architecture, and greater muscle mass. Let's look at how that actually works on the field, right?
Okay.
A different shoulder-to-hip ratio fundamentally changes how force is generated and absorbed in the body. A larger lung capacity increases the amount of oxygen delivered to muscles during a sprint. These don't just give a slight edge. In competitive sports, they are determinative.
I don't disagree with the mechanics of typical biology, but how does the law apply that to equal protection? Because
sports operate in a zero-sum environment. Every roster spot taken or medal won by a biological male directly displaces a female athlete. The majority points right back to the 1974 Javits Amendment to Title IX. That amendment explicitly required federal regulations to include, and I quote, reasonable provisions considering the nature of particular sports.
Right, but physical categories in sports serve the exact same protective function. Why should sex categories be treated differently?
I come at it from a different way. Because your wrestling analogy assumes the state is dealing with a uniform physiological advantage across the board. The state isn't just dealing with general weight classes here. They are dealing with a clearly identifiable subclass of people for whom their entire biological justification completely falls apart.
How so? Because the majority's ruling sanctions an unconstitutionally overbroad generalization. When a court applies intermediate scrutiny, the government cannot rely on broad stereotypes or general biological trends if there is a readily identifiable subclass that doesn't fit the trend.
You mean the transgender girls who haven't gone through male puberty?
Yes. In this case, that subclass is transgender girls like 15-year-old B.P.J. in West Virginia.
The middle school cross-country runner.
Exactly. She was diagnosed with gender dysphoria at 9 years old. She was prescribed puberty-blocking medication before the onset of endogenous male puberty, meaning the natural puberty produced by the body's own internal hormones. And, she later received estrogen therapy.
But she is still genetically and biologically male.
Genetically, yes. But physiologically, because of the blockers, she never experienced the mechanism of male puberty. Her body's clock was essentially paused.
Right.
She never developed the widened skeletal structure or the increased lung capacity that Justice Kavanaugh leans on so heavily. Because this specific subclass lacks those inherent physical advantages, categorically excluding them does absolutely nothing to serve the state's interest in safety or competitive fairness. Instead, it just inflicts severe harm. ACLU and Lambda Legal have highlighted this repeatedly. It targets a vulnerable minority, encourages invasive sex testing, and denies these kids the mental health benefits of sports.
But does intermediate scrutiny actually demand a perfect fit? Because if we look at how the majority applied precedent, specifically the Undergone case, they argue the law just has to be substantially related to the goal, not flawless.
It doesn't have to be perfect, no, but it has to take a hard look at the evidence. It can't just be a passing glance at a general trend.
Right, but in Nguyen, the court established that you can use a legal classification even if it doesn't perfectly capture every single individual case, because biological males as a general class possess inherent physical advantages over biological females. A categorical ban substantially relates to preserving fairness.
But
the law doesn't demand perfection. It just demands a realistic reflection of the fact that the sexes are differently situated when it comes to physical competition.
You're right that Nguyen allows for some generalization, but you can't ignore Justice Sotomayor's argument in her dissent. She points directly to the VMI case, United States, Virginia.
The Military Institute admissions case.
Exactly. The Supreme Court struck down VMI's male-only admissions policy because even if the vast majority of women could not meet the school's rigorous physical demands, there was a subclass of women who absolutely could.
Okay.
The state wasn't allowed to use a general truth to exclude the specific individuals who defied that generalization. The same legal logic applies perfectly to B.P.J. The state is relying on a general biological truth to penalize a specific group of transgender girls based on physiological traits they literally do not possess.
That's an interesting point, though I would frame it differently. Let's step back from transgender athletes for a second and look at cisgender boys. If a biologically male athlete who identifies as a boy happens to be physically smaller, slower, or weaker than the girls on the female team, equal protection doesn't require the school to let him play on the girls' team just because he lacks an advantage.
Well, because he's a boy.
Exactly. The state is perfectly permitted to exclude him from the female category based entirely on his biological sex at birth. So if his individual lack of physical capability doesn't earn him a spot on the girls' team, why should gender identity suddenly override the biological category if physical capability alone does not?
If the smaller, weaker cisgender boy is excluded constitutionally, the biological classification itself is doing the legal work, not an individualized assessment of his strength.
I'm sorry, but I just don't buy that. Let me tell you why. Your analogy conflates general everyday physical variation with the specific physiological markers of sex that the state claims it is trying to manage. The state isn't banning cisgender boys because they happen to be fast.
Right. It's banning them because the endogenous male puberty they undergo provides an overarching class advantage. A transgender girl who has had that puberty medically blocked does not share that class advantage. The biological mechanism of advantage just isn't there.
But this brings us exactly to how these policies have to be implemented on the ground. The majority points out that trying to mandate individualized assessments creates an impossible administrative quagmire.
I think quagmire is a bit of an exaggeration to excuse rights violations.
Think about what you're asking local institutions to do, though. You're asking high school athletic boards and local judges to act as endocrinologists. How does a volunteer school board equitably measure the specific, localized effects of puberty blockers or varying lengths of hormone treatments on a case-by-case, sport-by-sport basis? At what exact month of estrogen therapy does a bone density advantage disappear? The state legislature is far better equipped to draw a clear, administrable line than leaving it to a patchwork of amateur scientific valuations.
Administrative convenience has never been a sufficient justification to strip a marginalized group of equal protection. You can't just say, well, treating them fairly required too much paperwork. And beyond that, the administrative nightmare argument completely ignores recent history. From 2016 until their categorical ban in 2021, West Virginia actually used a case-by-case assessment model successfully.
But it was highly subjective.
It was a state board evaluating students based on age, athletic experience, and physiological metrics to see if their participation would negatively impact competitive equity. It worked. Furthermore, the NCAA and high school athletic associations managed individualized hormone-based eligibility rules for years without the whole system collapsing.
But the NCAA eventually had to change those rules because the science showed those individual assessments weren't mitigating the biological advantages.
We can get to the evolving science in a moment, but I want to look at the reality of the sports in question first. Take B.P.J's middle school cross-country team. They had a strict no-cuts policy. Literally every single student who tried out made the team.
Okay.
So in that specific factual context, it wasn't a zero-sum game. Not a single cisgender girl lost a roster spot to B.P.J. The state's entire justification about displaced female athletes completely evaporates in that scenario.
I'm not convinced by that line of reasoning because sports are, by their very nature, fundamentally competitive. Even if a team has no cuts, competition doesn't end at the roster. Every race run, every medal awarded, every placement matters.
But B.P.J. wasn't winning medals. She was finishing near the back of the pack.
That doesn't change the mechanism of competition. If a transgender girl places 15th in a cross-country meet, the biological female who crosses the finish line right behind her is pushed down to 16th.
I mean,
her placement is altered. The zero-sum nature applies to the race itself. We cannot legislate overarching constitutional law based on the anomaly of a no-cut middle school track team, especially when the broader ecosystem of sports, from college scholarships to starting positions to podium finishes, is fiercely zero-sum.
But if we are legislating overarching constitutional law, we have to examine the actual scientific foundations of the legislation being passed. You mentioned the NCAA changing its rules, but look at what intermediate scrutiny actually demands. Courts have to take a hard look at the evidence. The majority's opinion essentially applied rational basis deference while pretending to apply intermediate scrutiny.
They deferred to the legislature because the scientific landscape is heavily debated and evolving.
But the science the state legislatures used was deeply flawed. In Idaho, for example, the legislative findings used to justify the Little v. Hicox ban relied on studies to claim that testosterone suppression doesn't mitigate athletic advantages.
Right.
But one of the primary studies they cited didn't even involve transgender athletes at all. The author of another cited study explicitly asked the governor of Idaho to veto the law, stating her research had been grossly misrepresented. When a legislature bases an exclusionary law on distorted science, the judiciary absolutely must step in to protect the minority.
Okay, let's confront that scientific landscape directly, because it's not just rogue state legislatures drawing these conclusions. Look at the international sporting community. They have dramatically shifted their stance based on emerging physiological data. In 2025 and 2026, the International Olympic Committee, the USOPC, and the NCAA all moved to restrict transgender women from competing in female categories.
Following immense political pressure and threats to their federal funding, I might add.
Perhaps, but they also cited specific biological mechanisms. The IOC's policy noted that once endogenous male puberty occurs, certain traits are locked in.
Right, if it occurs.
Exactly. But the policy stated there is no current evidence that testosterone suppression or gender-affirming hormone treatment eliminates these advantages later. Once skeletal structure widens and bone density increases during early adolescence, simply removing testosterone later doesn't shrink the bones back down.
Sure.
That physical architecture remains, so we are dealing with profound scientific uncertainty regarding the exact physiological mitigation achieved by these treatments across a broad population.
But that is exactly why a categorical blanket ban is so legally offensive. It assumes the absolute worst-case biological scenario for every transgender girl, regardless of her actual physiology. It completely ignores the medical mechanism of puberty blockers, which actively prevent those very skeletal and muscular developments the IOC is concerned with in the first place.
Well, you are punishing a girl who never went through male puberty because of bone density advantages that she literally does not have.
But if the scientific community itself is deeply divided on how to measure and verify these biological realities across different populations, as evidenced by the IOC's pivot, isn't it the exact role of the democratic process rather than 9 unelected judges to draw the line? Asking the court to act as the ultimate peer review board seems outside the bounds of constitutional review. The legislature has to have the latitude to legislate in areas of evolving science to protect its citizens.
Deference to the legislature does not mean judicial abdication. When you implement a categorical ban under the guise of scientific certainty that does not exist, you are legislating based on fear and stereotype, and the collateral damage is profound.
In what way?
These laws validate a hyper-policing of femininity. We saw a 15-year-old cisgender girl in Florida subjected to a police investigation over her anatomy based on an anonymous tip. Cisgender athletes who are deemed too masculine face harassment and demands for biological verification. It creates a toxic biological checkpoint at the locker room door that undermines the entirety of Title IX.
I hear that concern, but...
And furthermore, as organizations like the National Women's Law Center point out, the real systemic threats to women's sports are unequal funding and rampant sexual abuse, not a microscopic percentage of transgender youth who just want to run track with their friends.
We've reached a critical juncture here in assessing what equal protection really means in the context of sports. To summarize my position, the Supreme Court's ruling firmly and appropriately protects the Title IX framework and equal protection rights of the vast majority of female athletes.
Right.
It recognizes a fundamental truth. Biological differences drive outcomes in the physical realm of sports. The decision affirms that states are not constitutionally forced to dismantle biological categories to accommodate gender identity when doing so compromises competitive fairness. The categories exist for a reason. They ensure that female athletes have a dedicated space where they can compete fairly, safely, and successfully.
And to summarize my position, this ruling represents a profound failure of equal protection for a marginalized group. By relying on overbroad generalizations, the court allowed states to legally sanction exclusion and stigma.
I see it differently, obviously.
They ignore the actual physiological realities of transgender girls who have never gone through male puberty, treating a specific subclass as theoretical threats rather than individual students. The 14th Amendment demands rigorous, nuanced scrutiny, but here the court prioritized administrative convenience, sacrificing the well-being of vulnerable youth.
This ruling, monumental as it is, clearly does not end the national conversation. As we step back from the strict legal doctrines of intermediate scrutiny, we have to acknowledge the immense difficulty of the underlying policy question. We are trying to balance categorical fairness for biological women, who fought for decades for a level playing field, with individual equity and compassion for transgender youth navigating an incredibly difficult path.
That's exactly right. The tension between those two deeply held values, fairness to a protected class of women and compassion for an individual's identity and right to participate, remains entirely unresolved in the broader cultural sphere. The court has spoken on the constitutional baseline, but the listeners really left to weigh the competing demands of biological categorization and individualized assessment for themselves. The moral and societal debate is undoubtedly going to continue.
If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.